They're citing that and using that as a way to indict him. However, there's no mention of the Presidential Records Act.
All right, let's take a look. Let's see here. How's the morning going?
It's just going pretty good.
I got to sift through the spam. Okay.
Also, real quick, your moderator. Hold on, really quick. Your moderators are blocking some of my people, by the way.
Oh, I'm not in control of that. Sit tight, everybody, and just fuck off. And are you reading the indictment? Do you have that up?
I don't have. I mean, I've read it several times.
My computer's slow right now, and I can't pull up the exact executive order that you're citing here. There we go. Blocking property of certain persons contributing to the conflict in Somalia. That's 13536?
13526.
13526, okay. Classified national security information, much better.
That's it.
Okay. And so what's the argument here?
So in the indictment, what they're doing is they're citing that he's in violation based off of Executive Order 13526. They're not putting him in violation of the Presidential Records Act, nor is it mentioned anywhere in the indictment or in any of the charges. So if we're talking about classified documents or we're talking about possession or any of that stuff, again, that would be mentioned somewhere in the indictment, but it's not.
Well, because he's not being charged under the Presidential Records Act.
But the Presidential Records Act would have to do with classified documents and whether or not he was allowed to have them.
So does 18
whether
USC.
he was allowed to declassify them, all of that, right?
Yeah, he's being charged under 18 USC here.
That's why, which is based off of Executive Order 135.
No, 18 USC predates that. This is 1924. You're looking at 2009.
Okay, right. But when we're talking about what is being cited, right?
See, it's at the top here, 18 USC 793E, Section E.
Okay, yeah, I understand that.
Where's the executive order? I'm not seeing that.
Executive Order 13526 is directly listed on the indictment.
No, it's not. I have the full thing here. It's at the top, right? Right. Yeah. It has the headers here. I'm not saying executive order.
Hold on.
Yeah, I don't know that we charge people under executive order, but it's not listed under the indictment here. Send in the clowns. There ought to be clowns. So, how's everybody doing? Let's go ahead and there you are.
Information. I think it's page 3 of the indictment.
Sweet. Oh yeah, where it has the quote where he says, "As president, I could declassify, but I can't now."
Sorry, page 5 of the indictment underneath.
Oh, okay, gotcha.
It's all of the executive orders and such.
That's not what he's being charged under. This just specifies the classification of the documents.
Yeah, which, okay, so again, underneath those documents, right, the executive orders, that's what they're saying he's in violation of. The other ones at the top, those don't extend to the executive level.
No, it doesn't say he's in violation of that order. This just specifies the level of classification that they have to undergo and the proper procedure in which one must declassify them. It doesn't say anything that he's in violation or is being charged under Executive Order 13, whatever you said.
Okay, so again, what they're citing, okay, so what they're citing underneath that whole thing right there is what he is in violation of, right? How he violated those terms in order for them to charge him with the 18 USCs.
Yeah,
but the
it lists out the violation. But that's how he's being charged under.
But the actual 18 USCs, those don't extend to the executive branch. That's why the PRA is existing.
Yeah,
because
the
he's not
PRA,
somebody who's,
right, but because he wasn't president when he committed the crime, so the PRA is irrelevant. PRA applies when he is president. So 18 USC is applicable after the presidency.
so at the time, right, at the time that he had possession of those documents and took those documents, he was president, wasn't he?
No.
Yeah, he was.
Post-presidency? No. Willful retention of the classified documents was not during his presidency.
So again, who says that they are classified?
So the designating officers that determine the classification level are the ones that would determine that.
Right. And which designated officers are those?
It depends on the level. It depends on the documents.
Right.
But
So
usually if it's military level,
Go ahead.
if it's military level, then they would be ones determining that. If it's FBI or CIA or whatever, determine the classification of it would oversee that.
Right. So that would be the Intelligence Act or it would be the Atomic Energy Act. Those are the only two things that he cannot declassify, correct?
Not the only two, no. But even
No,
if
they
he
are.
did,
They're really the only.
right. But the thing is, he didn't, though. I know. But the thing is, he did not.
Okay, hold on. But notice how neither one of those acts are actually cited in this indictment either.
Because they couldn't review them.
Huh?
They could not review levels of nuclear intelligence within reference to the evidence.
Okay.
So they couldn't submit them. At least 13 documents having that level of classification could not be reviewed by the people overseeing the indictment.
So again,
But if you read Section 3, I know if you read Section 3, he's admitting that he didn't declassify, so that kind of throws that argument out of the
how
question.
is he admitting that he didn't declassify?
Here you go. In July 2021 at Trump National Golf Course in Bedminster, New Jersey, during an audio recording meeting with the writer, a publisher, and two members of his staff, none of whom possessed a security clearance, Trump showed and described a plan of attack, and Trump said was preparing for him by the Department of Defense. Trump said, and I quote, "As president, I could have declassified it, and now I can't, but it's still a secret."
So again, that's already been explained. He met with them in New Jersey, right? They had a whole pile of articles, magazines, things like that, things of that nature, references from
Right,
when they
but they
were
didn't
interviewing him,
have-
right?
they
And
didn't
he
have
was
clearance.
pointing to the stack and they were asking him questions. And what he said is, I could have declassified this, but I didn't. So you can't
So
determine.
he was showing them? He
No,
was showing them?
no, no, no.
Yeah, they did. And they
No.
testified that they were being shown that?
No, they didn't.
They did?
No, they
That's-
didn't.
Yes,
Where
they
did they
did.
testify that they were being shown a classified document?
Where did they testify? It's listed in the indictment.
Yeah. Okay. So
They
can you
had
go
to-
to the specific part of the indictment where they said Donald Trump showed us and was in possession of a classified document?
March 20 is Section 7 here, March 30th, 2022. Federal Bureau of Investigation opened their investigation into that, and they testified under oath. So, yeah, these people have admitted that Donald Trump was showing them classified documents. They did not possess the clearance to handle them, and they were being moved around.
Okay. So can you tell me exactly what they said?
I don't know why that matters.
It does, because again, this has already been debunked by him and his attorneys.
By him? What has Donald Trump debunked about this?
He said that he was not showing classified documents, that they had reference materials that he was pointing to and holding up because they were
So
asking
showing
him
them.
questions.
He was showing
No,
off classified. It was marked
materials.
classified.
Their source materials. They were asking him about specific situations that occurred underneath his presidency. They brought source
He was
materials.
showing off a plan of attack. No, it wasn't source materials. It was a article. It was a packet listed as classified on the top of it.
So you're saying that Donald Trump packed up classified documents, put them in a briefcase, and took them to New Jersey because he knew exactly what they were going to ask him about?
They were already there
How are they already
because he
there?
had moved them there post-presidency. So after people leave the presidency, they pack up a shit ton of stuff and move them towards their respective property. At that point, he had them there at his property there.
So then why aren't they charging him with having the documents there in New Jersey?
Because they were moved to Mar-a-Lago.
They were moved. No, the only place that he's being charged is Florida. He's not being charged in
I
Jersey.
know, because they were moved to Mar-a-Lago. He had them there at the time of the interview
How do you know he
They
had them there at
moved
the
them.
time of the interview?
because it says that this took place in Bedminster, New Jersey.
Okay, so did he just happen to pull them out of his briefcase? Did he travel with them, or did he have them at the New
So
Jersey?
him traveling with it makes it even more of a crime because even still he doesn't possess the clearance to do such a thing. It doesn't make it better, but either he had them there or was traveling doesn't remove the criminality of the fact that they're classified documents and he's moving them around unlawfully.
So this is all just speculation then at that point, right?
What?
You don't know how he transported them, where they were at, where they came from, where he pulled them out.
I'm saying it doesn't matter because they're still classified.
Or could it be that they had source materials? They were asking him about things that happened in his presidency and he was pointing to the specific things that they were talking about.
if they testified under oath and showed that he was presenting classified documents, and they have a video of it, which isn't publicly available, but was released towards the Justice Department overseeing the indictment, yeah, I don't think that anyone could make the case that he wasn't showing off classified
So
documents.
I don't understand how we're going to be able
you
to
got a
debate if
violation.
your people
Excuse
are
me.
flagging me.
I didn't do anything.
No, but your people are reporting me.
Oh, well, I'm sorry. But yeah, he had classified documents and could not and should not have had them, was willfully retaining them, and that's what he's being charged under.
So again, but there's no evidence other than somebody saying on an audio recording, I could have declassified this, but I couldn't. And you don't know
It's
what he was
not
holding.
somebody, it's Trump and the people listed in the indictment.
But it was an audio
testified under
recording,
oath.
correct? It was an
Right,
audio
but the
recording?
people, yes, but the people under
Right.
oath have to testify as to whether or not the materials they were classified documents, which they did. They're not going to perjure themselves.
So they said in their testimony that he was holding up classified documents and showing them.
Yes.
No, they didn't.
What do you mean? No, they didn't. Yeah, they did.
No, they didn't.
Yes, they did.
All they did was submit the audio recording.
No, they did not. They have to
Yeah.
testify to verify what was happening, what was being done, what was being said, and where.
Okay, so again, how did they
You
testify?
can't just submit it without
how did
context.
they testify?
I already told you.
Okay, so again, how did they testify if it hasn't been to court yet?
They were interviewed. They had to
Oh, you mean
testify
they
before.
they just gave an affidavit or a statement?
No, they were interviewed prior and then had to go under oath.
Okay, so again, that would
That's
be
not what
a
an
sworn
affidavit would
statement
be.
or an affidavit.
Under oath. Before a court of law.
Testimony means that you're able to be cross-examined.
Mm-hmm.
Okay, so therefore that
So
hasn't
they were
happened
under
yet.
oath. They had a grand jury testimony, federal grand jury.
Yeah, and they didn't say anything about being shown classified documents.
Yeah, they did.
No, they didn't.
Okay, show me where they didn't.
Show me where they did.
Okay. How much have you actually read of the indictment?
The entire thing.
The entire thing?
Mm-hmm.
And wouldn't you know this?
Yeah, I do know it. That's why I'm asking you to look it up and show me where they said it.
Okay.
You made that
I
claim.
don't know that because I don't know that I have quotes, but I know that it happened because it's listed within the indictment.
Right. Can you show me where in their testimony, as you call it, that they said that they were shown physically classified documentation from Trump?
Sure. Oh, here we are. You guys can go ahead and take care of that.
Take care of what? You
Give
don't
me a
want
second.
gifting me?
No, I'm dealing with spam right now. I don't really care about the gifts. It's like 3 cents.
Sometimes leftists get triggered when I get gifted on a panel.
Yeah, I get called the N-word.
By who?
Right wingers.
Oh, sure. I'm sure.
I mean, it happened like twice this week. I sounded pretty triggered. One of former President Trump's assistants reportedly told federal investigators Trump wrote to-do lists on the back of classified documents. Here we go. This was Molly Michael told investigators the former president wrote requests and tasks on the back of note cards, which later realized were White House documents with visible classification markings.
Okay, so
Documents
again,
were
can you
reportedly
show
used to
me
brief-
in New Jersey, when they were interviewing Trump, that he was showing them classified documents? Can you go to that part?
Okay. Does the Mar-a-Lago one that I just listed not matter?
No, it really doesn't.
That's her dealing with classified material.
Okay, so again, you made the claim that in New Jersey,
Okay, so just New Jersey, okay?
that's what you were claiming.
Is that what you
let's
want?
just stick
So
to
not
that
the
one. If
Mar-a-Lago
you
one?
want to go to the next one after that,
Okay.
we'll go through that.
Let's see here. I don't know where I can find the exact quote other than the fact that it's documented that they gave sworn testimonies.
Okay, but you said in the sworn testimony in the indictment, they stated that he showed them classified documents. You made that
I know.
point.
I'm trying to find that quote.
Right.
You're right.
So
You're
when you
looking
find
for
it, let me
exact quotes. I don't know that I have that.
But you said the exact quote existed in the indictments. I'm asking you to provide that.
When did I say that?
You did say that.
I said that they gave sworn testimonies.
Yeah,
I don't
you
know that
gave
I said there
sworn
was a quote.
testimony that was listed in the indictment that I could easily read that says that they stated
Okay.
that they saw
I cannot find that. I concede that I cannot find their words. Okay.
Perfect. All right. So
Okay.
what was the other one that you wanted to talk about?
Does that remove the criminality of that?
No, but you have the burden of proof is on the prosecution.
Right. But like,
So that would
okay,
mean that they have
okay.
to provide proof. The only thing that the indictments do.
Yeah, I'm
is they
sorry
show
I
one
don't have the
side-
quotes of their
Hold on,
testimony.
I'm sorry. Hold on.
That's not what they do.
The only thing that indictments do, the only thing that the grand jury is shown is one side and one side only of a case. There's no defense. There's no rebuttal. There's no nothing. Anybody can get an indictment. Indictments aren't hard
That's
to
not
do.
true. Indictments are based on
aren't hard to-
evidence.
No, over 90% of all cases shown to a grand jury get indictments.
What?
Yeah, over 90% of all cases shown to a grand jury end in an indictment.
What is that? What the fuck does that have to do with it?
You said it's not. You said it's hard to get an indictment. I said it's easy to get.
No,
an
I said you
indictment.
needed evidence to indict.
Okay, again, one-sided evidence without any rebuttal or without any defense. So it's easy to
What is the
secure an
defense that
indictment
Trump
when
could
you're
have?
only hearing.
Trump's defense is that he declassified it.
Okay, well, again, we won't know until they go to court, right? Because he's actually not able to discuss things in public due to gag orders and things like that by judges.
What would make
So
this not a violation of 18 U.S.C.?
he's literally being tried in the court of public opinion without being able to give a defense. So until
but
he
they
goes
cannot
into
go
a
through a
court
grand
to
jury
give his
without
defense,
sufficient
we won't
evidence.
know. Okay,
You
so again,
cannot
what
go
would
through a
be?
grand jury without.
Yeah,
what?
you can. Over 90% of all cases that go to a grand jury
Citation, please.
get it. Oh my God. Oh, perfect. Hold on.
Sure.
Okay, I stand corrected. The Washington Post
Up.
Washington Post stated 99.9%.
W, Jayden. Get a W, Jayden in the box.
No, actually, I understated it. They actually get indictments. Federal grand juries give indictments 99.99% of the time. And that was in 2014 from the Washington Post.
And what does it have to do with your claim? Because I said that indictments require evidence to be submitted to a grand jury. You're just responding towards a non sequitur.
I said it's easy for anybody to get an indictment from a grand jury. It happens with over 90% of the time.
You need evidence.
Technically, I was still right, but
You need evidence to do
99.99%
that.
of the time, grand juries
Okay.
end up in an indictment.
Does that happen without evidence or with evidence?
Okay, so again, where does evidence get scrutinized?
Does that happen without evidence or with evidence?
So when does evidence get scrutinized in a case? Does it get scrutinized at the indictment level?
At the trial.
At the trial, right. So a lot of the evidence that they've put forth may not even be able to be used, depending.
Why not? They have photographic evidence. They have recordings of Donald Trump.
Because there has to be discovery, right? Which means that the prosecution has to give the defense all of the information in discovery, right? And then the defense can then go through and disseminate what they're going to challenge, what they're going to see is going to be admissible, not admissible, that kind of stuff. So again, even all of the stuff that's listed in the indictment might not even make it to the trial.
Yeah, I already said that certain levels of classification cannot undergo review because of the severity of it.
No, that's not the same thing. What I'm saying
Are you
is
saying something would be withheld?
Yeah, that's exactly what I'm saying.
What
I'm
would?
saying that there can be evidence that was given to the grand jury that for whatever reason can be challenged by the defense and be inadmissible in court. Happens all the time.
Such as what? In this particular case, what would?
They could redact certain things. They can throw things out and challenge it. Yes, they can. They most certainly can.
No, they can't.
Yeah, they really
In
can.
this documents case, why would they? And what exactly would be redacted?
Lots of things could be redacted. I
Like
mean,
what?
you could have people's names redacted. You have locations. You could have you can have an entire. I mean, look at the search warrant. The search warrant was heavily redacted. Anything that's released
To
or
the
anything
public
that's looked
view,
at
yes.
can be heavily redacted. It can also be heavily redacted in court or for the jury. The jury's the one that's going to decide the case.
Right, like the names of the people who testified under oath.
Possibly. That could be possible.
Well, that's what happened. That's why I can't find their quotes.
Okay, so again, anything that has been submitted to the grand jury doesn't necessarily mean it's going to be seen by the jury in court, because all evidence can be questioned and it can be challenged. Some stuff can be outright thrown out.
What would there be able to question? What would there be able to question of the fact that Trump's own words are saying that he could have declassified but didn't? Photographic evidence of the documents being handled by Trump in his ballroom, in his bathroom, and other places that weren't designated to have them.
Well, but here's the thing, Jayden, at the end of the day, we can sit here and speculate about this case all day long. We could do that. It's not, I mean, we could sit here and go back and forth and volley over it. It's really not cut and dry, because you haven't seen the evidence.
It is 18 U.S.C.
No, it's not.
Willful retention of classified documents. The evidence is already there.
So again, 18 U.S. Okay, hold on a second. 18 U.S.C. does not extend to the executive branch. 18 U.S.C. does not extend to the executive branch.
It applies post-presidency. Here it is. Title 18 U.S.C. 1924 makes it a federal crime to knowingly remove classified documents or material from their designated locations without authorization or retain them in an unauthorized area. Trump violated that law.
Pause. When he left, no, hold on. Pause for a second, because let me respond to that. So
he can do it while president. Yes.
Hold on.
After presidency, he can.
Okay, great. Did he go back into the White House? Did he go back into the White House after he was no longer president and go and get those documents and remove them? Or was he sitting president at the time he removed the documents?
He can lawfully remove, right? Can I answer, please? He can lawfully remove them as sitting president. After president, he cannot retain those documents. He has to give them back to NARA. NARA requested them.
So then it would be a property issue.
Can you not interrupt, please? No, it's a national security issue, because NARA had requested those documents. Trump had lied on sworn affidavits that he had submitted all of them. He did not. He ignored grand jury subpoenas requesting them.
Okay, so again, if
He's
there's a
authorized
dispute,
to give them back.
So if there's a dispute between NARA and Trump, or a former sitting president, when does it become criminal and not property?
When 18 U.S.C. is being violated. How is it a property issue? He doesn't have the...
It's a property issue. NARA is saying it belongs to them.
NARA makes the... No, they don't. NARA does not say that it belongs to him. They make the distinction between personal records and presidential records. Presidential records does
not have the ability to do that. It is the sole discretion of the president.
It's literally in
NARA. Federal court ruling. No, and the federal court ruling actually says in Judicial Watch v. NARA,
What federal court ruling? Okay.
Judicial Watch v. NARA. Okay. The judge made a ruling that states that NARA does not have the ability to determine what is a presidential record or what is a personal record. And it goes so far to say that
Can you read
president,
that? Can you read that for me? I've got that up here.
Judicial Watch v. NARA, right. If you go down to the opinion of the judge, it's the ruling of the judge all the way down. It gives the ruling, and what she states is that it is at the president's sole discretion and his alone.
Here's where you're wrong. Judicial Watch argued that Clinton should have included the tapes among records transferred to NARA at the end of the presidency, and that NARA had to take steps to obtain the records.
You're right.
Because that was labeled as presidential record.
Right. So go down to the ruling of the judge. That's what Judicial Watch was claiming, but go down to the judge's ruling on it, because it was dismissed. They didn't get the tapes. They didn't get the tapes. You know why? Because
why is this your legal argument if it was dismissed?
They dismissed it because
records, not classified documents.
They dismissed it because
that wasn't a matter of classified documents.
Can you not talk over me? You asked me a question. I'm trying to answer.
You've done that all day.
Go down. You need to go down.
You literally talked over me all day.
You need to go down to the ruling.
I want you to explain how this makes your case. Stop talking over me, please. Stop. This has to do with personal records.
That they were saying
classified documents. Stop interrupting me. Classified documents are not personal records. You're wrong.
Okay, so again, this was a dispute between what would be deemed a presidential or a personal record. It was dismissed because it wasn't
right. Recordings are
deemed a personal record. So can you please go down?
Because it wasn't deemed a presidential record. How would a classified document be? Excuse me. How would a classified document be ruled a personal record?
So again, if you go down to the ruling of the judge on that case, it's perfectly clear that NARA does not have the ability to differentiate or determine what is a personal or presidential record. It is at the sole discretion and the sole discretion alone of the president.
That's absolutely not true.
It absolutely is true. Go down and read the ruling.
NARA already makes that distinction between what is personal and what is classified.
A federal judge says they can't.
It does. No, it fucking doesn't. Diaries, journals, or other personal. Excuse me. Stop talking, please. It doesn't say that with reference to classified documents.
Presidential records.
Oh my fucking God. Diaries, journals, or other personal notes serving as functional equivalent of a diary or journal are what would be presidential or personal records, materials relating to private political associations, also personal records, and C, materials related exclusively to the president's own election to the office of presidency. Those are personal records. Something like a note that Bush wrote towards Clinton at the start of his presidency is not a presidential record.
Perfect.
It is a personal record.
But you know what happens?
A classified document would be protected under the Presidential Records Act.
So again, once a president during his presidency, because all these documents that we're talking about were all during Trump's presidency. Okay. This all happened during his presidency. Once he has possession of it, he can declassify it. He can deem it a personal record if he wants. He can do all of those things. It's at his full discretion.
Right, when he's president.
Right, and he did that while he was president.
No, he did not. He said that he didn't.
In order for your
Read
argument,
page 3. He says, as president, I could have declassified. Of course, now I can't. It's a secret.
But that's meaning that's only if he has possession of the document that you're talking about. And I am telling you,
which he did, and we know that he did because we seized them from him.
You can't prove that. No, you can't.
Because we have the affidavits that he lied on. No, we don't. That's not the only evidence. We have the affidavits that he lied. Excuse me. Stop interrupting. Stop interrupting, please.
You're interrupting me.
Excuse me. I was in the middle of talking. We have the sworn affidavits, which he lied on and said that he had returned all classified documents. We have photographic evidence where it shows the markings of classified documents at the header. We have pictures of the places where he was storing them in an unauthorized area, not a SCIF, not approved by NARA. All of that is cut and dry within the indictment.
Okay, within the indictment, right? But it doesn't state that he showed anybody any classified document. He said,
whether he showed someone or not is irrelevant to the fact that he was retaining them illegally.
No, that's absolutely relevant because that's what you were claiming.
Because he did.
I don't understand.
But even if he didn't,
keep interrupting me.
Even if he didn't show people, stop. Even if he didn't show people, doesn't remove the criminality of him willfully retaining and withholding classified documents in a place that he was not authorized to do so.
Are you done?
That's indicative of the pause, yeah.
Okay, great. So when
you want to talk to a lawyer?
Oh my God.
Well, I have a lawyer friend. She can explain it.
So again, in the end, I have a lawyer friend too.
Okay, right. Mother of Dragons?
Mm-hmm.
Or is that her identical twin that she claims?
Oh my God. You guys are really just so pressed. So the thing is, okay, again, in the indictment, you made the claim that he showed classified documents to the journalist in New Jersey. You cannot provide me proof of that. Why? Because it doesn't exist. There's an audio recording.
That's not the only evidence that there is towards the case.
For somebody who complains about being interrupted, you sure do interrupt a lot. So again,
I've been relatively positive towards you.
Okay. Jeez. Okay.
Katie, you want to hop in?
Oh, I thought it was just a 1v1.
Well, yeah, you can talk to her.
No, it was a 1v1.
She can explain it temporarily.
Oh, no.
Okay. I just thought that she as a legal expert could explain it. No, I don't. But I think she as a legal expert could make the case.
Oh, okay, great. Oh my God.
So you can talk to her one-on-one. I'll remain quiet.
Okay, fine.
I mean, if you want your debate, that's fine.
No, I'd like some legal expertise on this.
Okay.
Don't fucking complain about calling back up in the fucking 8v1 Republican held debates that I into all the fucking time.
But you asked me for a 1v1, sir. It's just strange that you're asking for help.
So now I'm taking a pause. I'm not asking for help. I'm asking for legal clarity, which is very much needed from a legal expert here.
Okay. What do you need to have clarified?
The law in which you don't understand seems to have been violated.
I mean, one thing I will correct you on is you were talking about the ruling in the case with, I guess,
Judicial Watch v. NARA?
So rulings in cases, they set precedent, they don't change laws.
Right, but they set precedent.
His case was dismissed, though, so that didn't set anything.
Well, no, it was no. The ruling sets precedent. The ruling itself will set precedent. It was dismissed, correct? But the ruling itself sets precedent.
Correct, but that's not law. Like, precedent isn't necessarily something that no judge is going to say, okay, well, this is it every single time. That's a law. The precedent is not the same.
Okay, so do you know, was there anywhere that I implied it was the law? I just said that it was a ruling.
Well, it makes no sense why you would bring up a case that was dismissed.
Because it sets precedents, correct? Rulings set precedents. So there was a ruling by a federal judge.
Dismissals don't.
Okay, so again, a ruling, not a dismissal, where it doesn't matter how the case is adjudicated. It doesn't even matter what the result was. Hold on a second. The ruling itself set the precedents, and that precedence that was set was distinguishing the difference between NARA and the president, and what the powers were to be able to determine what was a presidential record and what was a personal record. That's why that ruling, i.e. precedence, has already been set prior to and can now be used as a defense.
So I haven't read this, so I can't say like what exactly it says or anything, but I will say this: if we talk about rulings and things, we can look at the ruling against Trump in the E. Jean Carroll case, correct? So
that's a civil case.
I understand that, but it still was a ruling, and the judge said, which was what was entered into the congressional record, was that he did grape her. Now the ruling says that it was only SA. So do you see the difference there? It's one ruling is not going to be everything for the end all be all.
But a civil case and a criminal case, that's like comparing apples and oranges, because a civil case is liable and a criminal case is different, right? And we can also say that even the terms and the parameters in a civil case and a federal case are different. For example, in a jury, you just need a majority of the jury in a civil case, but you need all of them on board in a federal case.
You're missing the point, but it's okay.
Well,
can you explain it to Roberta, please?
I mean, the point is what the judges said.
Okay, so again, the judge actually said that he couldn't say that there was any evidence that he actually essayed her. Actually said that there was just evidence of sexual harassment, correct?
Correct. So basically what you have in a fucking lawsuit that was dismissed is just what a judge comments.
Right, but it sets precedent. Like that case, for example, set precedent because they actually changed the law, changing the statute of limitations to allow that to be filed.
No, man, like nobody is going to refer to a dismissed case for precedent.
Yeah, they will, because it's a ruling.
Okay. Why would they? Okay. It's not. It's not, though. If it's dismissed, why would they use that as precedent?
Even cases that are dismissed, right?
Can you name any other case that's been dismissed that's used as precedent?
Yeah, several. Just go look up
They can be used, but why would anybody refer to a dismissed case?
Because again, a federal judge ruling, okay, sets precedents, especially when you're talking about something specific. You have NARA, who's claiming something against a former sitting U.S. president, okay? You also had the same thing happen with Judicial Watch, also with a former sitting U.S. president, right? And it's all based off of records. What is a presidential record and what is a personal record? So it is actually the closest thing. You can also look at maybe versus Egan as well, which also sets a precedent for this case. But because for the interest of time, we'll just stick with this one.
The precedent has already been set with the distinction between personal and presidential records within classified documents. That would fall under presidential records, hence why NARA has a system for reserving them, for authorizing their classification, for how they document them.
But they can't determine what is the difference between a presidential and a personal record.
They do have that laid out. You want me to explain the difference?
Sure.
Okay. What are presidential records under the PRA? Presidential records means documentary materials created or received by the president, the president's immediate staff, or a unit or individual of the executive office of the president whose function is to advise or assist the president in the course of conducting activities which relate to or have an effect upon carrying out of the constitutional, statutory, or other official or ceremonial duties as president. So that would fall under the category of classified documents because that's done in the official presidential capacity. That's done in the executive office.
Yet the Presidential Records Act is not cited.
Because it's in reference towards 18 USC. You said that they did.
No, it is not.
It says it at the header.
The reason why the PRA exists is to govern the executive branch because 18 USC does not apply.
Post-presidency, he's no longer applicable.
But everything that he is being accused of happened while he was president.
No, it doesn't.
Yes,
Retention of classified documents. You cannot retain classified documents while you're president. It has to do everything. It has everything to do with post-presidency. That's why he's being charged post-presidency. If he could do it while president, nothing would be a problem. He wasn't at the time that he was found liable of this.
He hasn't been found liable of anything other than his New York case, which is the civil case. He hasn't been found liable of anything.
Was he president when he
was president at the time? He was not president. He was president. Oh my God. Can I answer the question you just asked me? He was president at the time. He removed the documents from the White House.
And after that, what happens? He has to give them back, right?
No, he doesn't have to give them back.
Yes, he does.
Again, it's an argument between what he deems at his sole discretion what
That
is
is
a
NARA's
residential
rule.
or personal record.
That is NARA's right. NARA determines what is classified.
States that NARA does not have the ability to do that.
No, it does not.
The
Yes, it
ruling,
does not.
Ma'am, the ruling, they would only be able to associate that ruling if there was another lawsuit.
You mean like the one that's going right now?
No, I mean, okay, if he had taken them after the president, right, and he said that, oh, they're his to decide. If the governments had sued him for taking them and not deciding, then there would be another lawsuit. But yes, they could use that as a precedent in this one now. But the only time that you even really use precedents is when the case isn't necessarily lining up with the law. And in this one, it's pretty clear.
But it's not, because if it was, then the Presidential Records Act would be cited, and it's not. The reason
Because
why
he
the Presidential
didn't violate the Presidential Records Act.
Right. Thank you for explaining that to Jayden. I appreciate
Oh my God.
Jayden knows that.
That does not defeat
He
my
didn't
argument.
violate
I've already
the
said
man.
that.
Oh my God.
I have
He
said that
didn't-
multiple times. That
How
that
many
the presidential
times?
records.
Okay, so on
Stop
this
talking,
live, Jayden,
please.
how many?
I've said this multiple times since the beginning that it's in reference to 18 USC. Not the presidential.
Okay, so then
records
why
Act.
do you keep
Stop
referencing
talking,
the
please.
PRA?
I am
You
not.
do.
Every
You
single
are.
time. You are. I have
You are,
not
Lynn.
at any point referenced the Presidential Records Act. I've only stuck to the case of 18 USC. You came in here and claimed that the Presidential Records Act was listed at the top and that he was being charged under
No,
that.
I said it
corrected
wasn't.
you.
I said it wasn't.
Yes, you did. You said it was at the very top.
No,
You
I
said
said
it was
only
listed
the
at the very top.
executive orders are. What do you mean?
You said it was listed at the very
PRA
top
is not
and then
mentioned
changed it.
anywhere in the indictment.
I
You're the
have
one that
no
keeps
point
bringing up the
referenced the
PRA.
PRA. No, I have not. And if you've been tracking the conversation, I've
God.
only
Oh,
ever
I
referenced
can't.
18 USC.
I can't.
I know you
really
can. I know you
really
can.
can't. This is crazy. Do you want to switch to a different
Because
topic
you're a
now?
gaslighter.
I am literally not. I literally said the Presidential Records Act is not mentioned anywhere in the indictment, only Executive Order 13526, which meant that you went and looked it up, right?
And I told you
showed
because he wasn't
exactly
being
where
charged
in
under the
indictment
PRA.
it was. Oh my God. And
I
then
already
told you
told
exactly
you.
on the indictment where Executive Order 13526 was mentioned, not the Presidential Records Act, yet here you are continually bringing up the Presidential Records Act.
Because
You
you
referenced
just
that in
did, Glenn.
you referenced that within the executive order, which cites the PRA. That's not what he's being charged under. You
my
claim that he
God.
was. Oh my God!
No,
Follow
I
your
didn't. I
own
said it was
argument.
under-
Yes,
oh my God.
yes, it is. You said that he was being charged under the PRA. I corrected you and said 18 USC is the law that he's
Wrong. I would
violated.
never have said that. I said he was being
That was the
charged
first
with
thing
the
you said. I
executive
take
order.
notes when I debate,
It was
okay?
based
That
off
was
the
what you
executive
said.
order. You didn't even know what the executive order
Right, that's
was.
cited.
I had to
I
point
do
it out
because
to
it's
you.
on page 5.
Oh my God. But you read the whole indictment, right?
Yes,
But you didn't know about Executive Order 13526?
because you said that he was violating the Presidential Records Act.
No, I didn't. I never
Yes, you
said
did.
that. No, I said,
And I
why is the
clarified.
PRA not mentioned anywhere in the indictment?
And I told you because he's not being charged under that.
Right, exactly. So I said there's no point in even bringing up the PRA because it's not a bone of contention in this
I
case.
didn't bring up the PRA.
Yes, you just did. You've done it like
No,
3 or
I
4
didn't.
times now. Yes, you have.
Because the Presidential Records Act applies prior to when you're out of office. It designates the course of action that you must use for declassifying and classifying information and what can be done in terms of SCIFs, in terms of how you can store them in the transitional period and things of that nature. But it has nothing to do with the fact that he willfully retained those documents post-presidency.
Great.
That's why
Jayden, can you
18
do me a
USC.
favor?
Can
Since
you listen, please?
since
That's
you
why,
brought it-
excuse me.
Hold on
Excuse
a
me, Lynn.
second. Since
Excuse me.
real
Just let me
quick,
finish,
real
please.
quick.
I'm almost done. Just let me finish. Okay. That is why 18 USC is what's being referenced at the head of the indictment and not the Presidential Records Act.
Okay, great. So can you bring up MJ for me?
Why?
He's in the queue.
Do I know MJ?
I don't know if you know him or not.
All right. Is he your lawyer friend?
No.
Oh, no, I'm on strike. I'm not a lawyer.
You're on strike?
Yeah.
What do you do?
3 years. I'll stick it to the man.
What do you do?
Nothing. I'm on strike. Currently unemployed.
All right. Well, woo me with your legal expertise.
So here's my question. So if the PRA isn't relevant here, and which is why, I mean, evidently he's been charged under the Espionage Act.
I never said it wasn't relevant.
Okay, so it is relevant.
Yes.
Okay.
I'm saying
All
he's
right.
not being charged under the Presidential Records Act. That's all that I've said.
Yeah, but see, that's the thing that's got me confused is, again, the Espionage Act is for officers, subordinates, things like that, whereas the executive branch is held under the PRA and the executive orders, correct?
He was no longer a president, so therefore not part of the executive branch.
So therefore the PRA doesn't matter. But yet it was used to throw out the Clinton case. So it must be
Because the
relevant.
Clinton
Because
case
that
is a
had to do with
completely different
personal.
case.
That had to do with whether or not that would fall under presidential records or personal records. There's
Yeah,
a
no,
very clear
I agree
distinction
with that.
between classified documents and recordings.
Okay, so the president, and again, we understand according to the PRA that the president's the only person that has the ability to dictate what is personal and what is presidential, right?
No.
No,
Where
it
does
doesn't.
it not say that?
What
Within
you're
the
talking
Presidential
okay.
Records Act.
What you're talking
2203K,
I read it
the
for
only
you.
reference to the entire
I read the
statute,
distinction.
designation of records as personal versus presidential. Also
Right. It
calls
makes
for
the
decisions
distinction
made by
between
the
what is
executive.
classified.
Okay,
It
so
makes
now
the
we're
distinction
talking.
between what is personal and what is classified information or presidential records. Classified information would fall under that.
Okay, so the president cannot unilaterally declassify anything that is classified outside of the two scopes of acts of Congress, in which he can't.
With relation to nuclear things or military
Those
documents,
would
he
be under the
cannot.
two acts of Congress.
And even still, under executive order, that would still have to go under review of the designating officer that would determine the classification. So
Yeah,
it's
but
not like
that
a one-time
falls.
thing that he can just wipe away.
Yeah, no, I agree with you there. But what you just described, actually falls under the two acts of Congress, which are the only classified documents that he cannot unilaterally declassify. Anything outside
Right.
of those two acts of Congress, he
There
can't.
is still a procedure to declassify. It's not like he can
I'll
just
tell you what,
blink
you
his
can
eyes
Google
like
Right.
Genie.
And the
But
procedure
let
isn't
me
a
ask you something. Let me say something to you, MJ. So you're referencing the Sox case and the trial there and everything, the outcome stuff, right? Correct?
Yeah, I'm
Okay.
speculating is all I'm doing. I'm giving you
Cool,
my
cool,
opinion.
cool,
I don't know.
cool,
I'm not
cool.
an attorney.
So what happened is, Clinton had to go to trial to find out if the stuff that he has was classified or not classified, and if he had broke the law. Correct?
Mhm.
That's exactly what's happening to Trump right now, sir.
Oh, I agree. This is legal theory. I mean, absolutely. This is
Okay, so
unprecedented.
so basically you're just debating your theories.
Correct. As well as everybody
Can we
else.
debate the law?
There's absolutely zero precedent here.
Well, your friend doesn't seem to understand that.
Well, I mean, but we have to understand and we have to be honest when it comes down to the fact that, again, like I said a while ago, you can Google forever and you will not find anything as to the extent as the presidential's legal authority to unilaterally declassify material not covered under those two acts of Congress. And without formalities, it is yet to be challenged in court, ever.
That would be a good point if he was president at the time that he was retaining those documents. He wasn't.
I understand that. So why was there not a charge of violation of the Intelligence and Identities Act of 47, or actually it would go back to 82 because it was a kick-on of the NSA of 47, or not a charge of the Atomic Energy Act of 54?
I don't know.
The fact that those two, and see, that's the thing, Jayden. The fact that neither one of those charges are there make me question the validity of everything else, because those would actually be the two easiest things to prove. Other than that, anything outside of those two acts of Congress, he actually has the authority to declassify by whatever means he sees necessary, and it's never been challenged in court.
I will tell you why it's not there. There were some documents that he has that they were not able to prosecute him on because they were too sensitive to even show the judge and jury, and so they could not include them because they could not, rightfully show them what the documents were.
Okay, where is that written?
Hold on, Liz. I disagree with that because, again, we're indicting him and we're using charges based off of sworn testimony. It would only take one officer to testify under oath that that document does in fact fall underneath one of those acts of Congress. That would be very easy to do.
You could, but maybe they don't want to do them. I mean, I can't speak as to why they chose what to, what to and what to not. Obviously, when we go and indict people, we're going to try to indict them, or we're going to indict them on what we have the strongest case on. And so if those two were not the strongest, or if those two were too involved, we're obviously not going to ask for them to be in the indictment.
Is it possible that neither one of those could even be involved at all?
I mean, you seem smart. You know anything's possible.
Yeah, so that's what raises a lot of
Right,
flags.
so if there isn't
which is
that-
why I ask a lot of questions. If that's not there, now we're getting to the argument, does he in fact have the ability to unilaterally declassify anything outside of that? And that's where we have to take into account the PRA, the Executive Order
Right.
13526.
That's applicable
and
when
all
you're
of that.
president.
Yeah.
Right. Those things are applicable, and I'm sure you know this, when you are president. He's not. So whether they had to do with nukes or atomic energy or anything, military strategy, or was just something a little lesser on the classification level, is irrelevant to the fact that he had no authorization to view them, to maintain them, to handle them, and to keep them in his possession in an in an undisclosed area.
Yeah, and I think we're all kind of getting on the same page here as to why this raises.
I don't
so many
think we
questions.
are.
Well, that's
I
debatable.
think any president that withholds classified information post-presidency is in violation of the law.
Well, again, you just agreed And I think we were all on the same page that
I don't think Lynn is.
Declassify it.
Yeah,
When he is president.
Yeah, so when he left the office, the mirror basically, and again, he can declassify it by whatever means necessary. There's nothing that says, and I
When
think
he's
there needs to
president.
be.
no,
I
what?
think there needs to be, but there's nothing that says that he has to write down this, he has to notate this, he has to notify this person outside of those two acts of Congress, right?
So he cannot unilaterally declassify it on his own. They do have to be notified for that, because otherwise they can just ignore
No,
his
I
will
understand.
if they're not
I understand,
told.
Jayden.
Like,
But-
is it really
but
plausible
basically
that
the
one
act
could
of
just
him
think
walking
away
out
the
of the White
classification
House-
levels?
I understand, but basically him taking the documents outside of the White House, the mere action of him doing that alone could be an act of declassification.
How?
All he's got to do
No.
is say they're declassified.
What? No.
All he's got to do is
No, he can't.
No.
That still has to undergo
no,
review
no,
process.
no.
no, it doesn't.
Yes, it
You're
does.
going to have to.
Yes,
that's
it
true.
does.
If he's on his way
Cannot-
out, then they would still have to undergo that review and determine whether or not that's necessary for the National Archives to retain or for him to retain.
Again, that
I mean,
power falls
there's
directly under the
absolutely a
executive.
process to declassify.
No,
there is
it's
a
not.
They
process.
can't not see it.
Yes, sir, there is.
They can't not
Show
see
me.
those documents.
Show me outside of those two acts of Congress in which he cannot unilaterally declassify a classified document.
He can when he is president. He didn't,
Hang
though.
on.
Him taking it
That's
out of
the
the White
argument.
House could be deemed
It's
as
right.
declassification.
If he declassified while he was president, then sure.
Yeah.
But he didn't.
When he
And
left,
he admitted
he
it
packed it up
on
and
his
put it
own
in a box.
admission. He did not declassify.
Well, you
Where
don't even know that
he
document
didn't
that you're
declassify.
talking about. You're talking about the
He
document.
said, and I quote, "As president, I could have declassified. Of course, now it's a secret."
Okay,
but we
so
don't even know
again,
which document that pertains to. As a matter of
Exactly.
fact, there
It
is
does not
even a
matter.
document
It
singled
doesn't
out.
matter though if it's declassified
If it's
or
source
if it's
information,
classified.
absolutely it matters.
If the information is still classified, then it doesn't matter whether or not he should have the right to have it.
I understand that,
He
Jayden, but
couldn't.
you're still going to have to
Right.
show me the document in which he was talking to, and you're still going to have that individual.
It
be able
doesn't
to
matter if it's
point out-
classified.
Yeah,
If it's marked as classified,
If it's
it
a
does not
newspaper-
matter what the document is.
if it's a newspaper article and she's referring to a story about a troop
Then it
or a
wouldn't be
battle plan that was
classified.
being implemented, well, yeah, it would.
They do
Lynn, did
because
you
they
read
have
the
them.
executive order that you quoted in the beginning?
13526.
what about it?
Have you guys read it about
Yeah.
declassification? So it's not going to say there's not a specific rule for a president to declassify. The rule relates to the type of declassification that's being done. It's not going to say specifically which member of what party of who can. It has different ways to declassify. There's one way across the board for everyone to declassify different levels from different departments.
So Executive Order 13526 is only cited in one section. And the main reason behind it is because what they're trying to show is that he was going to, most of the section had to also do with intent to harm the United States by showing documents that were highly classified to people of other
Title
countries,
18.
things like that, right? So
Title
again,
18. That's not the executive order. That's Title 18.
no, it's in the executive order as well.
But let's be clear on executive orders also. They derive their powers solely from the president, meaning that the president doesn't even have to follow his own rules because the authority governing those executive orders comes directly from him.
You said 13292, right?
No, 13526.
Okay. Well, she listed, okay, 13526. Right. So here's what it says. Information was classified as top secret if the unauthorized disclosure of that information reasonably could be expected to cause exceptionally grave damage to the national security that the original classification authority was able to identify or describe. Ultimately, what that says was people that designated the classification level deemed that to be of top secret of those documents, the ones labeled top secret that he could not have. Below that says secret and then confidential. Same process. President cannot declassify those.
So again, there's
Post-presidency
only
especially
two.
can't.
Right. So there's only two entities again that he would have to go through a declassification process. Now, if you look at
There are
did.
only two. No, there are
Yeah,
only two.
hold on.
No, there are
Hold on,
only
she
two
goes
that
with-
require Congress.
Yes, no, but hold on. She is right in a sense. There are more than two entities. And I mean, it could be the FBI, the CIA, the Department of Defense. It could be the Navy. It could be the Department of Energy. Okay. But what
Right.
she's talking about the two acts of Congress in which
Right.
all of those documents will fall under.
correct,
Which Trump did not go through.
because
Which-
again,
that's my point.
yeah, if you look at the
What is the point?
documents,
If he did
so-
not
Why wasn't he
classify, if
charged under
Congress
those-
did not go through the process of declassification, then
Again, that's what raises all the questions.
you're arguing that there's a
Okay.
legality towards this, towards his
No,
ability
no,
to
no.
keep them if they didn't.
No, that's
what?
what I'm arguing.
This is a
why
walking
wasn't he
contradiction
charged
here,
with that?
MJ.
No, it's not. Why wasn't
I
he
don't
charged
know,
with
and
that?
I'm not the courts. I'm not the one that determines that. But it's
Okay,
the willful
now, I
retention
agree
of classified
and
information.
here's the thing. Hold on. I will agree with you. and I think Lindsay will agree with you also. If in fact he had a document in his possession that falls underneath either one of those acts of Congress, okay, we agree 100, or at least I do, but I think I speak for her as well. We agree 100% his ass should be playing spades in Gitmo for the rest of his
Yeah,
life.
he did something wrong.
Okay,
Which he
I'm only
did.
questioning.
It's a matter of coming to common ground. Just a second, this is my life. It's a matter of coming to common ground as to whether or not you understand what he did was against the law. You are arguing that he didn't commit a crime. He did. 18 USC. It's listed at the very top. Willful retention of classified documents. And he knew he was breaking the law.
I'm arguing
He had lied on sworn affidavits.
I'm questioning the fact that if that is in fact true, why were neither one of those charges brought forth? Because they would be the easiest charges and the most damning charges to him. They would be the easiest ones to prove.
As Katie indicated, because of the because of their classification level, they could not be reviewed by a court of law. They have to undergo the designating officers that determine that.
All you need is sworn testimony from one officer. You've got an indictment full of sworn testimony. All you need is one individual to testify as to, yes, that document falls.
When it relates to when it relates to military or nuclear information, okay, but within reference to other things of lesser classification level, is still irrelevant to the fact that he had willfully retained those documents in a capacity that he was not able to do that. Right, there is no defense.
If he would have been charged for violation of the Atomic Energy Act or violation of the Intelligence and Identities Act, there's absolutely no defense that he could pose.
Okay,
but the fact that he's not being charged,
of the lesser extremities.
with either one of
But
those,
no one is
question
going
the whole
to.
case.
You have to understand though how that testify would work. So if you have the lesser non-classified or classified documents, you can have someone that can go up there and say, hey, yes, this pertains to, Iran war plans, this is that. What are you going to have if it's violating those two? What are you going to have somebody go up there on court and stand and say, like, yeah, these two things he has, and they were bad?
Because those documents are actually by law required to be stored in a federally secure location, can only be and cannot be taken out.
But what I'm saying,
even be taken
which
out
NARA sets up.
Location.
But what I'm
Trump
saying
did not
is,
have that.
So therefore, it'd be very easy to prove. We don't charge people with
It is.
NARA doesn't oversee.
You just made the case. You just made the case.
But NARA doesn't oversee DOE. DOE oversees their own documents.
NARA does oversee whether or not a SCIF can be applied towards holding those documents, which he did not have. Trump did not have a legally authorized SCIF set up in place for storing them and retaining them.
So do you know what FRD stands for?
FRD?
Formally redacted?
Yep, formally restricted
Was it?
data. Formally
Was it?
restricted data. Actually, yeah, the documents in question in the indictment, especially the ones that pertain to nuclear documents, all said FRD on it. So once it's FRD, it's out of the DOE, right? It's not just
and that does not make
anymore.
it. That does not give him the authority to keep them because it's still government property. That's not a personal record. It's still government property. Stop. It's still government property. That is still government property.
So again, he cannot declassify something from the DOE. NARA can't do that. NARA doesn't even house the DOE stuff. The Department of Energy
FRD does not mean declassified.
It says formally restricted data, right?
That does not mean declassified. Ma'am, that does not mean declassified. Then why are you arguing that?
Real quick, I'm sorry, real quick. I've got to jump off. I appreciate you guys. Jayden, I appreciate you letting me up. Kate, enjoyed talking with you. Linz,
see you later, MJ.
Awesome. Yeah, I'm willing to talk about this anytime. I only have about 5 or 10 minutes, but yeah, thank you.
Okay.
Okay, so if you look at the Department of Energy's website, when they're talking about the documents that are labeled FRD, right? Formally restricted data would apply to things such as arsenals, what the amounts were, locations, things like that. So it's basically based off of supply. Now, the classification process there is that the DOE will then declassify that once it becomes obsolete. They hand it over to the DOD. The DOD then.
Okay.
So at that point, it is entirely plausible that Trump can then declassify that at the DOD level, especially considering
But he didn't.
deemed it obsolete.
He didn't, Lynn.
But you don't know that.
He didn't, though.
But you don't know that.
We do,
Yes,
because they are
because
still marked as classified.
There
And they
is
seized them from his
still a
possession.
process.
That is
It was
government property.
actually marked FRD.
I do not understand. I don't understand whether it's marked FRD or not. Does not give him the personal right to retain those documents because it's not personal documentation at that point. It is government
And it's not
property. No matter what you may say, it is government property. Trump
So
does not have the authority to keep them.
do you know that the second he writes a note on any document, it becomes his?
That's not
No.
true.
Yeah,
That is not true.
based off the PRA, it does.
No, ma'am, that's not true.
That is very true.
It doesn't make it a personal record. Oh my God.
It
No, it
does.
doesn't. Holy fuck.
Yes, it
No,
does.
doesn't. If he fucking,
It does.
if his
Lynn.
fingerprints were on the damn document, that doesn't make it a personal record.
You seem
Yeah, it
really
does.
smart. Listen, you seem really smart.
Does she?
You have to. Yes, she does. You have to like realize that doesn't make any sense. That this man can go and write some chick's phone number on a nuclear war plan and it be okay. That doesn't make it his. I mean, you have to
Alright,
think
hold on a
about
second.
this
I'll pull it.
rationally. The portion becomes a memo, not the entire document, okay?
Right. Personal documents, as specified, are private political associations, records pertaining to that, diaries, journals, or other personal notes. A note on a classified document does not make it a sticky note at that point. That doesn't make it not classified. That is still a classified document. You're just
right.
negligible at that point. Right. That is
Well,
still
but-
classified
but-
as a presidential record, not a personal one.
Okay, but if you handwrite something on there, then don't you alter the document or mutilate the document? And isn't that something that
That
he's
doesn't
being
render it
charged with
null
in
and
there?
void.
No, but
No, it
again,
doesn't, ma'am.
it's
Ma'am, it
something-
doesn't. It
it's-
only makes that portion a memo. It only makes that portion of what he wrote on there a private memo. It doesn't
Okay,
negate
so-
the rest of the document.
But again, in that case,
And
in the
normal
charges, he's
people-
literally charged with that.
Normal people don't go around, or normal presidents don't go
that?
around writing on war plans.
Do we need to go over
Where's that in the indictment?
Do we need to go over the charges in Florida?
Yeah, where does it say that he wrote on the documents?
Okay, let's go through the charges.
Okay.
So there's 32 counts of unlawful retention of national defense information, 1 count of conspiracy to obstruct justice. Then he has 1 count of withholding documents, corruptly concealing documents, 1 count of concealing federal investigation, scheme to conceal, false statements, altering, destroying, mutilating, concealing an object, or corruptly altering, destroying, mutilating, concealing an object or record.
Concealing.
No.
That's what it says.
Altering, destroying, mutilating, concealing an object, or corruptly altering, destroying, mutilating, concealing object or record, which means any of those things can apply.
Okay. Well, then he must have done something in that realm.
Right? Like written notes on that document, especially considering that a lot of those documents were actually press briefings from his office.
If they've specified already that that's not lawful for him to write on classified documents and then make that a personal document, then I don't see how that gives him any legal leeway here.
But
And
again,
if it's a press briefing and he wrote on it, they're not going to claim like it's mutilated or whatever. It's just a press briefing.
but he's actually being charged in all of those counts, those 34 counts, it literally lists press briefings in there.
Where?
If you look at the individual 34 counts, it talks about each document, and it actually lists press briefings in there.
I mean, can you tell me where? This is the longest fucking indictment, so I'm trying to.
I think it was
Find where you-
probably like after page 10, I want to say. I think it's only like 50 pages.
So, I mean, I get that, yeah, there's going to be a multitude of different types of documents. I mean, he had a shit ton of boxes. But you said there's only 2 charges of him mutilating whatever, concealing that, correct?
Well, there's one count of concealing, and then there's another count of corruptly concealing. So there, it's kind of like a double charge in a sense, but one is concealing, but could it be with intent? And then corruptly means that he was meaning to do it, right?
I think that, I don't know. I think that, didn't they find them in 2 different places? One was in a bathroom and one was in a locked
in a ballroom.
closet.
By the
I'm
way,
wondering
you
if
wanted
the
quotes.
locked area
Yeah.
is the one that's just regular, and the second one was the crudely concealing. I don't know.
All of the documents that they recovered were on the grounds of the estate in Florida.
Yeah,
Right.
yeah.
Not a legally authorized skiff for him to hold those documents.
No, we know. I think what I was saying is that if one group was found, let's say in a locked closet, that may be for your first concealing charge, and if the other one was like just left out in a bathroom that anyone uses, that may be your second concealment charge.
Okay, so also you all are aware that Nara actually was given access to the estate for them to come in, and they actually told him they just wanted him to put a bigger lock on the door?
No, they told him to give it back.
No, they actually told him to put a bigger lock, a more secure
So
lock.
no, he was requested to put them back until the point that designated officers for handling them can come back and seize those documents. Up until that point, he was authorized towards locking them up. That part is true, yes. Now, after the fact, he was still asked and was told to have given them back. They said that they gave them back. They had lied on sworn affidavits multiple times, and ultimately what they seized back were what was left.
So allegedly, because again, it depends on what is deemed a personal record or a presidential record.
We know now that they were presidential records. Based on the charges that you read, he wouldn't be charged if they were seizing private records.
Again, what remains to be seen is what was classified, what was declassified, what was a presidential record, and what was a personal record. And again, we could sit here and argue this all day long. We really could, but it's all going to be subjective, right? Because
Not really.
until evidence is presented on both sides, he was innocent until proven guilty in our judicial system, and he has to be proven guilty in a court of law, not a court of public opinion. And both sides need to be able to bring forth whatever evidence, witnesses, or whatever.
Of course.
Right.
But you know that the court of public opinion never works that way.
Right,
know
but
they don't.
again, we're not dealing with the court of public opinion. I mean, they're trying.
We
him
are.
in
That's
the-
why we're having this live. This live is the court of public opinion. We're laying any evidence, the laws that were broken, how he did them, and why it's illegal.
Yeah, but we can't see the evidence.
We don't have the capability to do that.
We can't
because they're
even see. We
classified
can't even see
documents.
all of the evidence.
Because
Right,
they're
we
classified
can't even see all the
documents.
evidence that the grand jury even saw. So again,
Which-
I mean, we could sit here and argue this all that we want, but at the bottom line is this: regardless of what you think or I think or anybody else thinks, it's only going to matter what the jury thinks, right? And they're going to determine whether he's innocent or guilty, and it's going to be after he is able to exercise his rights of due process and able to defend himself. But again, the burden of proof falls on the prosecution.
Right. So for one reason to do these is because a lot of people have no clue how the judicial system works. A lot of people, like
agree.
you, have brought up a couple of things that weren't true, and so a lot of people don't know how to find out what's true or how to interpret what's true and stuff. So this is mainly, to explain to people, I guess, or questions of people's idea on where things go, so that they can be educated on these things. But still, court of public opinion, yes, we don't have both sides, but that is where smart people like all of us get in and speculates, I guess, in a way on how we think it will turn out, or what we think they have, or how the law should correlate with this thing. So I mean, that's why they call it the court of public opinion, because yes, we're going to specify and try to think about how this is going to all play out. That's just human nature at this point.
Right. So you see
Also,
the Department,
Lynn,
you see the Department of
also, we
Justice
do
going
have the
after.
evidence.
So you see the Department of Justice going after a Republican candidate during an election year using the court
This
system.
was before.
It's
It has nothing to
Documents
do.
were seized before he ran.
Yeah, it has nothing to do with his political affiliation. The investigation was started before he decided to run. Most of the investigations started before he was even out of office. But either way, I mean, if we live in this system and we have to trust that our judicial system is going to work the way that it should. That's why there are so many checks and balances. That's why, both sides get to do the voir dire, and that's why both sides, get to submit the evidence, and why we have jury of our peers, so that it's not one person that decides what happens or what's not. So we have checks and balances in the court system. And I think one problem that I have, especially because I am a member of the court, it's really disingenuous for people to say, oh, everybody in the court is corrupt, or, oh, this judge is a Republican or a Democrat, when, it's nonpartisan in the courtroom, as always. And most judges are fair. But not only that, you've got your jury system, and that's the whole reason that we have juries, so that, people don't get railroaded and things like that.
No, I agree with you. But again, I don't think that the intention really has anything to do with actually convicting him in a court of law. I think that the intent of all of this is to try him in a court of public opinion during an election year.
It has nothing
This
to do
wouldn't
with
be
an
an issue if
election
he
year.
didn't willfully retain.
Would you
And
expect
just a
him to
second,
finish an Okay.
Yeah, so we do have a detailed list. Here's from the United States District Court, Southern District of Florida, West Palm Beach Division. This is a detailed list of property inventory pursuant to the court's preliminary order. List out exactly which documents, exactly which ones were classified, which ones were personal records. Overall, we see some of highly confidential, of top secret, and of secret. None of them of which he possessed the capability of retaining. It's a list of 33 items, breaks down what was in each box.
Okay,
At the very top, item A, U.S. government document with secret classification markings. There's one without secret classification markings. Then there's magazines, there's classified, confidential, secret, top secret. The list goes on. It's all
right, but it actually tells you exactly what those are, and a lot of them are press briefings or things like that.
It
correct?
absolutely does. Yes,
Right.
yes, and it specifies which ones were classified.
So do you think? Okay, great. So and it was during his entire presidency, right? All of these documents were obtained during his presidency.
Post-presidency, when they seized them, he did not have the right to retain them.
Okay, so again,
He's no
all
longer
of
an
these
official of the
documents that
government.
are listed on this indictment were all dates and documents that were generated during his presidency, correct?
Yes.
All right,
Yes,
great,
yes,
great.
that doesn't
So
transfer.
during his
Excuse me,
presidency, so
excuse me. Let me finish, please. Let me finish, please, Lynn, please. That does not transfer post-presidency. That is no longer his authorization towards keeping them, towards dictating the confidentiality of them, towards maintaining them. After the fact that he is a government official, that is then property of the government. Those things like newspaper clippings, of course he can keep. I'm not arguing that. Classified documents are no longer considered personal documents that he can retain.
Well, that's going to be the question before the court, because again, we have a federal court ruling that states
It's not a
otherwise.
question.
It is a question.
No, we don't. Presidents
Yes.
cannot retain classified documents post-presidency. Even if they were classified during presidency and were not declassified, that doesn't give them the authority to keep
If
them
they were
just because
taken
they were
and
president when they
secured.
had them.
If they were taken and secured
While president.
during his
yes,
presidency,
because
then
they had
yes.
established a SCIF. They had established a SCIF. Post-presidency, there is no SCIF order for him to keep it there at his property. NARA has to dictate where those documents can be stored. They did. He did not give them back to them. So, therefore, he was not keeping them in a secure location as approved by NARA. He was not keeping documents that he should have, that he was keeping documents that he should have had, that he should not have had.
Okay, so you're asserting that he didn't have a skiff, right?
We know that he didn't based on the photographic evidence submitted towards the indictment. There was no SCIF set up post-presidency at Mar-a-Lago. And usually they aren't set up at the properties. NARA usually sets them up in Washington or on other federal land. But yeah, Trump did not keep his documents in a SCIF at Mar-a-Lago because you don't have a SCIF. The moment you're not president, that property, wherever you're at, no longer is government approved.
Yeah, an open bathroom is definitely not one.
But again, you asked me for a 1v1 debate on specific topics, and you brought
Right.
somebody else in.
And I did maintain that, all right? I added her for legal expertise, and we've not dogpiled you. You had the right to leave if you wanted to. I've kept it civil.
I can
And
talk before.
I
it's a
never promised
1v1.
anything.
It was.
I never
listen,
promised
It doesn't
anything,
matter
though.
at this
And we
point.
did
But
have
it
a
was a
1v1.
It was a
But we
1v1
did.
debate, right? And then you brought
Right,
somebody
we
up.
did have one.
Right. So then I brought somebody up. Since you
Right,
brought
is that a
somebody up,
problem?
right? No, it's not a problem.
Right, so it's
I'm
fine.
just laying the premise because you brought it up, saying, "Well, don't talk to me about this because I pile on 8. I get 8v1."
Right,
I do the
because-
same
I
thing.
know, because the
but
fucking
you
people in the
asked-
comments-
But you asked for a 1v1, and then you violated.
And I gave you that.
No, you didn't.
I did not promise anything. I didn't promise anything.
I can drop.
I asked for a 1v1,
like I
and I
said, I
gave you
really
that.
don't care. I just am pointing that out.
Why is it a problem?
I didn't say it was a problem. You brought it up for like the third time on your live now, so I'm just pointing that out again.
I know. I'm reminding the audience that it's a little hypocritical to chastise me for bringing in one guest versus the fucking 8v1 lives that you're typically in.
Okay, so again, I go into 8v1 lives and leftist lives all the time. I
You
understand.
don't.
Yes, I do. All the time.
When's the last one you've been in?
I was just in oil spills live on an 8v1
What was
like
the topic?
3 days ago. What was
Really?
the
I
topic?
never see you on 8v1 lives. Usually you're with Mother of Dragons or
No,
whoever the fuck
Mother
snacks.
Dragons, and I don't
AJ.
typically debate. And when I go into Dr. No Jobs live, I go in by myself as well. And that's always
Can I just
8v1.
ask, why have you guys normalized scalping in your sort of corner? I think that's fairly disgusting, but I want to know, like, what is the joke behind that?
Because Mother Dragons is indigenous.
She's indigenous?
Mm-hmm.
That
Wait, what
makes
is the scalping thing?
scalping okay?
Oh my gosh.
I mean,
Are
I'm
you gonna say
indigenous
that that's
too,
not
and I'm
politically
opposed
correct?
to. Well, I'm indigenous too, and I'm opposed to scalping.
It's just kind of a joke. I mean, it's not meant to be taken literally.
I
I
don't
know
know.
it's
It's
not
not
meant to be
very.
taken literally, but it's just a little
Right. I don't understand why
over
it's
the line, I'd say.
It was a really traumatic thing that happened to my ancestors specifically, so I don't think it was a joke at all. Can you explain like why?
I'm literally not crying about this. He's the one that keeps bringing
I'm not
up.
crying either. I just asked like, what is the joke behind it? I didn't know she was indigenous, but like, I find it weird that that's been normalized.
How can you explain how it's funny so that we can understand?
No, I think it's funny that the people in the comments are saying that I'm crying about this when I'm really not.
Okay.
I'm just pointing out that Jayden asked me for a 1v1 yesterday
Okay,
on 3
don't worry about the
specific
comments.
topics. Hold on.
Right.
But-
And for
but
45
Jayden was
minutes, we had a
addressing the
1v1.
comments. But Jayden was addressing the comments. That's what started
Okay,
this.
go ahead, Lynn. No, go ahead.
We're
Okay,
talking about the
so
scout.
do we want to move on to a different topic now, or are we good?
What would you like to debate, Lynn? Yeah, do you want to move on to the next topic?
I kind of want to know before I leave, like, what was the joke on the scalping? Can you explain what the joke
She's
part of it?
indigenous, so when she goes and debates people, then she says she collected a scalp. Meaning, she won, she slayed. People say I slayed that debate, whatever. She just says I scalped. Same kind of thing, same kind of premise. Some people
That's
say
one
I
of the
smoked that
most
person, I slayed that
fucked up
person. She
things.
says I scalped him.
That's one of the most fucked up things I've ever heard.
Okay, well, I don't know what to tell you. That you're entitled to your opinion, but
And so that's funny to you though.
I didn't really give an opinion on it. But if you have an issue with it, I suggest you go take it up with her.
No, you said that it was funny.
No, I didn't. I said it was meant as a joke. Just like someone says, I smoked that person, I slayed that person. She says, I collected a scalp. If you have an issue with it, then go ask her about it.
I have to clear something up. So you realize that I don't care if they're indigenous or the case may be, which is very clear.
No, another one.
No. I want to be very clear here. So what they're doing is pushing indigenous erasure, which was the reason for people doing that in the first place, claiming that indigenous people would do that to the colonizers, when in all honesty, it was the colonizers that did it to the indigenous people. They had bounties on us that they would pay out. To the equivalent today would be about $5,000 US for each male and about $3,000 for each female. Okay, they started that practice to go against us, and then they spreaded false information claiming that we were doing it. Which, so what they're pushing right now is colonialism. It is not.
So again, if you guys have an issue with something that MOD says,
Okay,
then I
well, we'll
suggest
talk
you go
you
take
about
it
it
up
too.
with
So, we'll talk to you about it too.
Sure.
So
I
that
mean, I don't
you
really
know.
care to talk
I don't
to
know
her.
why you're
Further-
talking. Why are you talking to me
It
about
further.
Well, I just asked.
you-
I'm just
okay,
asking
okay,
about
wait
it
a minute.
'cause-
What MOD does?
I know.
is
I'm
MOD
just asking you. Just
talk
one
to
second,
her.
Lynn. I was asking you because I've noticed it's not just MOD, but it's people that have trans scalp collectors on their bios and other conservatives that have now adopted scalper in their bio. So I was curious because you usually hang out around them.
So maybe we'll say
MOD
this
is
for
my best
everyone in the.
friend, but that
Okay,
doesn't mean.
Okay. Like it would be like if I said I'm lynching conservatives.
Yeah.
Okay.
I mean, it just
Anyways, you guys
further.
talk to her. I'll be right back. I'm gonna get the mail real
Okay.
quick.
It just further pushes the stereotype that supposedly we were savages, which is totally the opposite when they were against us.
Yeah, I just want to clarify. So it's funny that you referred to us as the quote unquote savages, but we had to teach you how to bake, brush your teeth.
Who said anything about calling anybody savages?
Oh, no, this is what you did, and then justified, then on top of that, because we were quote unquote savages, to quote unquote go
What
around
are
and
you
do that
talking
thing that you are claiming is okay to say.
She didn't.
I didn't.
No,
She never
but-
said that we were
but
savages.
they
She never
might
said
not
that.
have. They might not have said that, but the point here is when they're justifying going around and saying going and scalping people, it's pushing that stereotype upon us that we were savages. So whether they say it directly or indirectly, when you justify saying those things, that
Okay,
is what you do.
then go take it up with her.
So my
Is
question
my name Mod?
okay,
Is my name Mother Dragons? No? Okay, cool. Can you go and ask her about it then?
You were coming up here to try and use it to justify your point of view, meaning you agree.
I was asked about it. I was
Meaning
asked.
you were
Oh my God. I
agreeing
was asked by the host about something that MOD says. Okay.
You're sitting-
When I debate, okay, I don't sit there and say scalp collected after I debate. Okay. So yeah. Nor do I have a profile name that has anything about collecting any scalps. I don't have it written on anything on my accounts. So again, go talk to her about that, not me.
So to be clear, do you say that it's okay that they say it? Yes or no?
I don't care.
Oh, crap. Okay, I'm back. What I miss?
Apparently they don't care. So thank you for allowing me to come up and have to say my piece, because obviously they don't care what they're doing or
I don't care what other people do, nor am I going to sit there and tone police people or say what they can and cannot say. It's none of my business. They have freedom of speech. Get over it. If you have feelings about it, go talk to her.
Again, you see where this is.
Sure.
But anyways, thank you, Jayden, for allowing me up. You have a good one.
Of course, I appreciate you. I was just asking, what's the motherfucking thing about?
It's just a joke. I mean, it's something that somebody put in their profile one day, and we thought it looked really cool. So all of us just kind of thought, oh, we'll add that to ours as well. It's not a big deal. It doesn't mean anything. There's no hidden term behind it at all.
How do I get that on my thing?
If I type something in the comments, then you can go and click on it, and then you can copy it, and then you can paste it into your profile name if that's what you want to do.
Yeah, it's just one of the font generators. They use all the different fonts. Okay, so I'm going to drop down so that you can have your 1v1, okay?
Okay, sure.
I mean, unless you want me to stay.
No, I figured Lynn was done talking.
Okay. All right, well, I'll still be in the comments. It was nice talking to you, Lynn.
Sure.
Nice talking to you.
Yeah, stick around. So, Lynn, you enjoying yourself? Have I been a pretty decent host to you?
No, it's typical debate.
Yeah, but I haven't been awful, right?
Not too terrible.
Yeah, damn right I haven't. All right, well, what other topic speaks to you here?
You brought up re-election, you brought up Trump's guilt, and you brought up party switch. So which one of those do you want to tackle next?
We could talk re-election. I don't think Trump's going to win. I don't think he can win.
Okay, well, I think he's probably going to win. So there's that. He's head of the GOP. He'll be the GOP's front runner. So he's ahead by a lot and hasn't really had to say much. And he's ahead of Biden in the polls.
Polls this far out don't really mean much. Romney was 6 points ahead of Obama nationally at this point, and we see how that turned out.
Okay, but as of right now, he's leading.
Voters, just a second, please. Right, as of right now, but ultimately 2/3 of voters in the general say that they won't vote for a convicted felon. It's looking like his legal qualms won't be done away with as soon as the next few months, and may even exacerbate the problem for him. I think the second he goes on stage and opens his mouth, it's not going to be pretty for him.
Well, he's actually been going around and speaking at rallies and things like that. So he's not being exactly quiet. He just doesn't feel the need to debate with the other GOP people because, he's way ahead of them. So until that gap gets less wide and narrows, he doesn't see a need for it.
But do you ever take a moment and step back and ask yourself if you could continue to support him?
Well, so far, they've shown me a reason why I shouldn't. If anything, they've only shown me a reason why I should support him more.
What are those reasons?
Well, they're going after his constitutional rights. They are going after his freedom of speech. They are railroading him. They are trying him in the court of public opinion because they're scared of him. So if I don't like the government and they're scared of him, then
what constitutional rights are they going after?
Well, his freedom of speech, number one, is one of them.
So?
His due process as well.
He has due process. He's in court.
Yeah, but he's being tried in a court of public opinion, number one, and he's not allowed to defend himself. And
he is allowed to defend himself.
Also, there's laws being changed just
Does he not have lawyers?
Prosecute him in certain areas. There's also things that have already been looked into, and other states are. Yeah, the Federal Election Commission looked into the New York case.
Specifically using the RICO law.
So the Federal Election Commission actually looked into the New York case, and they didn't.
That's all.
New York is taking it on as ridiculous, and the DOJ has actually condemned Alvin Bragg for doing that.
What law was changed there?
Well, in the New York case, they have a whole bunch of counts on him, but the only way, and they're saying that they're felonies, but in order to do that, because those are misdemeanors, they actually have to be attached to a felony charge to do so, and they haven't disclosed what the original underlying felony charges in order to make those misdemeanors felonies. So that's on that case. On the New York case with the civil case, they actually
they do have those attached.
Yeah, but they have not disclosed what the original felony is. They've only disclosed the misdemeanors that they've turned into felonies, but they haven't released or disclosed what originally
falsifying business records.
No, he has. Okay, so again, in New York, Let me get to my sheet here.
Right, Alvin Bragg.
In New York, he has 34 counts of falsifying business records in the first degree. Those are misdemeanors. The only way that they can turn him into a felony is if it was an act of a felony, but they haven't disclosed or released what that original felony is to bump those misdemeanors up to felonies. In the New York civil trial, they actually changed the law on the statute of limitations for a 6-month window in order for them to be able to file that one. So then when you go down to Florida, that one's okay. The Georgia thing is a train wreck. As far as the powers that be with that, on top of trying to slap somebody with RICO violations. And the only reason why they're doing that is because they're trying to get other people to roll on him and testify against him. That's typically why RICO violations and RICO charges are filed and why they get as many people in that net as possible. So having said
the
all
reason
that,
we're
do you want to
upgraded to
switch to another
felonies is because
topic?
of federal.
We're not
Well, no, we didn't.
agree.
I didn't even get to respond. What? I didn't even respond. What do you mean
Okay,
haven't
go
settled
ahead.
that?
Go ahead.
Okay. The reason why they've been upgraded to felonies is because of multiple federal banking violations, embezzlements being cited, sex crimes being cited, and Trump Corporation, Trump Payroll Corp state tax crimes. So all of those would elicit victims in these instances, and there were victims.
Okay.
Falsifying business records is a first degree Class E felony on 34 counts.
Okay, so 34 counts was 34 checks, correct?
No, what the what?
Yeah, it is.
34
It's 34
checks?
checks. Mm-hmm. Now, did he sign those
It's
checks? or
checks,
did
it's
it count?
invoices, it's general ledger entries
Yeah, that are all
with the
linked to
intent to
same
commit.
exact thing. The invoice and the check are
It's
two
not
separate
just
parts of the same
checks.
thing. Okay, so who
General
generates
ledger
the
entries
okay.
with the intent
General
to
ledger,
commit
okay.
with the intent to commit or conceal another crime, including state or federal election laws. That is a crime.
Okay, so general
They're not
ledger.
the same.
Okay, so
Invoices and
again,
checks aren't
these
the same.
34 counts are considered misdemeanors. Okay, these 34 counts that we're talking about, they are
No, they're
all
not. They're considered
misdemeanors.
felony because they're done on the federal level.
No,
violated
because
federal
no,
election
because
laws.
no, because again, they have to attach those misdemeanors to a felony in order to make those misdemeanors felony, which they have not disclosed yet.
They
That's a
did,
violation.
falsifying business records.
No, false. That's 34
Class
counts
A
of
felony.
false. Oh my God. Hold on.
Class E felony, excuse me. Falsifying business records in the first degree is a Class E felony.
I understand that. But in order to turn
Okay,
these
then how is it
into
upgraded?
felonies, because in order to turn these into felonies, they have to be attached to an original felony charge. Otherwise, they're misdemeanors. They have not disclosed what the original
The
felony
original
charge
felony
is.
charge was the first degree falsifying of business records. How is that undisclosed?
Okay. 34 counts of the same thing are all misdemeanors. They have to be attached to another felony,
No, they're not.
a different felony charge.
Those
Yes.
are the felonies, ma'am. Those are the felonies.
They are a felony.
Why would they have to
because
be
they were
attached to something else?
So they are a felony because they were upgraded to a felony because they're supposed to be attached to another felony, but they haven't disclosed what that felony charge is. It's just 34
Okay. What are they
counts.
supposed to be? What are they supposed to be attached to make it a valid felony?
So again, it has to be a felony
Can
charge.
you just answer that, please?
I'm
What has to
trying
be attached towards it?
There has to be a
repeating
felony
yourself.
charge of something that is related to, but is different than the 34 counts in order to upgrade these misdemeanors into a felony. There has to be another felony count of something else attached to it, and they haven't disclosed it yet.
Right. I'm asking, what would that something be?
It would have to be a different charge altogether. It would have to be a different felony, like embezzlement,
That's
felony
listed.
felony fraud, something
That's
like that.
listed.
No, there's
Embezzlement is
34
listed. What? Yes, it is.
34 counts of falsifying business records in the
Right.
first degree.
They list as examples of false business records case. Embezzlement is one of the things. Federal
Okay.
banking violations is the second one, and sex crimes is the third.
Sex crimes. In what? Are you talking about the civil case?
Of
There's two cases.
prostitution.
Hold on a sec. No, there's okay.
We're talking about Alvin Bragg, okay,
Hold on.
which is falsifying of business records to influence the 2016 election by paying off a porn star that he was fucking while his wife was recovering from a pregnancy in 2005. Heaven, I'm in heaven. Silence is nice. What an upstanding Christian. I'm not a Christian. In fact, I rejected an offer to go to church today. And I'd say even still, I'm more morally upstanding than Donald Trump. heaven. Jayden, where's Irish been these last couple days? I'm not really friends with Irish. I follow some of his accounts just to keep up with some of the entertaining or controversial things that happen there, but I wouldn't say that we have a rapport or friendship or alliance of any degree. She's actually correct, but go on. Well, she's been quiet for being correct.
I'm researching to get the document you want. And
No, go ahead.
one, so just hang on a sec.
Go ahead. Fly me to the moon, let me play amongst the stars. Let me see what life is like on Jupiter and Mars. In other words, what comes next? In other words,
Hold my hand.
hold my hand. What are you doing? Go research. In other words, baby, kiss me. Fill my heart with song and let me sing forevermore. You are all I long for, all I worship and adore. In other words, please be true. In other words, oh, fuck you. Didn't know I could hit that note. I haven't had any moisture. What the fuck am I looking at?
It's actually a CNN article, but it puts it out perfectly.
You trust CNN?
Sure, because it's literally saying the same exact thing that everybody else says. But I wasn't going to go with a right-leaning one because I knew you would debunk that. So
I don't trust CNN. And you guys need to stop with this caricature that the left is CNN.
Can you make it big?
No, can you just tell me what the website is and I'll read it on my own here?
Sure.
I don't trust the fake news media.
You're going to look at why Donald Trump's hush money case is risky.
It doesn't make it null and void or not a felony.
It doesn't.
Okay.
It just read it because it actually states that he has to attach it to something else, but he's not required to disclose it at this juncture. But that they have to have some additional evidence.
Let's take a little look here. I don't know that this is based off legal expertise or more or less just an op-ed written by a CNN contributor. But let's see. I don't know why my computer's so slow today. God damn. Oh, yeah, it's because of all the shit ton of tabs I have open. I have just about every legal document, every case, every indictment, the law pertaining to them in like 19 tabs right now. And on the 20th is a picture of my girlfriend's ass to keep me focused. But speaking of, well, we got you guys here. Let's go to effects. Take a look at my girlfriend. Day on the 20th. Her birthday's on the 25th. And we're going to be together. Pretty hot, isn't she? So, you know, Venmo Cash App in the bio. I don't know why TikTok coins are taking forever to dish out. Prosecutors are not obligated to show their hand at the stage of the proceedings, and there are minimal requirements for what an indictment must say. Okay. Well, why don't the host post that video of Trump in 1987 to show the world how much he cares about us? What video? Is Barrister trying to join?
You want to bring another phone a friend up?
No.
Okay, good.
People are asking me to add them. Okay. So, how is everyone? It's a little quiet today. There's a lot of people watching. It's pretty good for a Sunday Live. I think it's so funny. Whenever I see lives, oh, there you are.
I've been here the whole time. I've just been muted. Did you want to stay on this topic? Did you want to go to the third topic? What do we want to do here?
I mean, if you want to move on, I don't know what your argument is at this point, that it has to be attached to something else to make it a felony.
Yeah, so in order to upgrade them to felonies, there has to be another charge, like trying to conceal a crime or something like that. That's a felony. And again, he hasn't disclosed it yet because he's saying he's not required to disclose it at this juncture.
Yeah, he's legally not obligated to do that.
Right.
Which I don't really see a problem with. I think.
Right. Okay, I don't see a problem. Listen, what I'm saying, what my claim was, is that these are not standalone felonies on their own. They are actually misdemeanors. In order to upgrade them to felonies, you have to attach them to another felony. You said that wasn't the case, right? You said they were felonies on their own.
No, I asked you what would he have to attach it to.
Right.
I didn't say it's not the case.
Right. And then I just brought up the source information to show you that he doesn't have to disclose it at this juncture. I'm not saying he's doing anything wrong. However, he hasn't disclosed the felony that it's attached to yet.
Okay.
And again, this was the first case that was brought.
Upgraded it. Right.
Right. But we don't know what that original felony charge is.
Okay. We will.
Okay. Well, you said
they'd have to be attached for it to be upgraded to felony in the first place.
That's what I said.
Him disclosing it is kind of irrelevant to the matter. All right. Well, what else would you like to talk about?
Did you want to talk about the party switch? Because that's the last topic that you came up with.
All right. You don't think it happened?
Nope.
Why are Democrats trying to take down the Confederate flag?
That's what you're going with? So are you talking about the rebel flag? Because the rebel flag and the Confederate flag are actually different.
Sure, the rebel flag. I understand that, but Confederate statues, to be more specific.
So is the South Democratic all of a sudden? I thought it was Republican.
The South was conservative and always has been.
Okay, so there wasn't a mass exodus of millions of Dixiecrats after the Civil Rights Act was passed?
There were, to the Republican Party.
No.
Are you familiar with the Southern strategy?
Left the region. No, they left the region.
Yeah, the mass exodus. No, the exodus wasn't about regional no, it wasn't a regional issue. It was about party affiliation. So when you say that they left the South, no, not geographically speaking. They absolutely did not go up to the north or what have you. Dixiecrats changed their political affiliation to Republican.
So if you actually go and look at the Lyndon Johnson Library, it actually talks.
Is it George Wallace?
What?
What were we saying? I must have gotten the quotes confused, although Goldwater did run on an anti.
Oh, no, actually, Goldwater didn't run on the anti. He was actually very pro-civil rights. He just voted against the Civil Rights Act of 1964. Yes, he did. In 1964, he actually...
He was pro-segregation.
No, he wasn't. Not at all. Not even a little bit. As a matter of fact, if you look at the speech that he gave on the House floor when he voted against it, it'll tell you all you need to know. He actually voted pro-civil rights every other time.
He argued that discrimination against minorities was wrong, but measures to end it were also wrong and infringed upon the right of association.
Because of Title II and Title VII. Title II and Title VII had already been ruled on by the Supreme Court, so he deemed it to be unconstitutional. He didn't want Title II and Title VII in there because it infringed on other people's civil liberties. So he always was pro-civil rights.
For pro-civil rights. How can you say that he was pro-civil rights? But he didn't vote for it, by the way. Voting records suggest that he did not vote for it.
He voted for it in 1957.
To say he supported it in theory. He
voted for the Civil Rights Act in 1957 and 1960. The only reason why he voted against it in 1964 was due to Title II and Title VII, and he explained that perfectly clear. However, if we look at history, because because the Supreme Court deemed it unconstitutional, which meant in order for him to vote for this, he would have had to go against the Constitution, and because he was a constitutionalist, he was not going to do that. However, he desegregated his own family business in the 1930s, long before segregation was.
How is that?
Desegregation was even a thing.
The civil rights movement. I mean,
Okay,
what
so
ruled the civil
Title
rights
II
movement
and Title
unconstitutional according to
VII,
him?
forcing people to,
Right.
okay, so Title II and Title VII of the Civil Rights Act of 1954 or 1964 basically stated that people were then going to be forced to, allow, any sort of businesses, they couldn't turn services away. They couldn't not sell to somebody or whatever the case is. And that's a violation of somebody's civil liberties, and has since been overturned.
It's not on the basis of protected class, which the Civil Rights Movement, which the Civil Rights Act had established, that your race is a protected class, not to be discriminated against. Why he would argue otherwise, or that it sets a legal downturn for him, is a problem. That he would see that as a rights violation, that he could not discriminate against black people, or that other people could not, I think is problematic.
Well, you can think it's problematic all you want, but the Constitution is what he was concerned about. He was concerned about upholding the Supreme Court's ruling that had to do with the Constitution, upholding the Constitution. You can't force people to do anything. If you have to force people,
it's not forcing them to do anything. It's forcing them not to do something.
Your rights.
It is forcing them not to discriminate. You don't have the right to discriminate.
I'm not saying you have the right to discriminate. You shouldn't discriminate against somebody, but you can't force people into something either, because that's a violation of their constitutional rights. And since then, the Supreme Court agreed with Barry Goldwater, because they also overturned that. You could refuse service to anyone for any reason.
Not on the basis of protected class. That's what the Civil Rights Act has implemented.
But then you would have to prove that it was based off of protected class. But again, that
being black is a protected class.
There was a Supreme
The whole
Court
argument was on the subject of their race and discrimination
Barry Goldwater
thereof.
was very pro civil rights. He was very pro.
Very pro is not accurate.
Yes, it is.
No, it's not.
Would you give me the big screen, because I have his speech pulled up if you'd like?
What does he say?
Are you going to give me the big screen?
Just tell me what he says.
So again, what he says is that he has always been pro civil rights. He voted for civil rights in 1957 and in 1960, even though the Democrats tried to filibuster it in the longest filibuster in history. However, he could not in good conscience vote for this Civil Rights Act because of Title II and Title VII, because it goes against and infringes on other people's constitutional rights, and he wasn't going to go against the Constitution. And obviously he was right, because there was a Supreme Court ruling prior upholding what he was saying, and the Supreme Court came in afterwards and upheld what he was saying.
All right. What ruling are you referencing?
It was in 1883. Hold on, let me go look.
I think I know what you're going to talk about. Getting pretty hungry. I haven't had breakfast today.
109 US 3, 1883.
USC 3, 1883?
No, US 3, 1883. There's actually 5 cases. They consolidated them into one. But if you look at the trend, Roosevelt, the reason why people voted for Roosevelt, even though he was a Democrat, was because they were voting for the person and his policies, not necessarily because he was a Democrat. Dwight Eisenhower followed that, and he actually overwhelmingly had the black population voting for him, as he won both the popular vote and the electoral college. And then John F. Kennedy, that's where things started to shift, because John F. Kennedy ran underneath the Democratic ticket. The reason why he ran under the Democratic ticket is because that's what his dad wanted him to run under, even though he was abhorrently opposed to his father's political views, as could be cited when his father was the ambassador underneath another president, U.S. president, and he actually was against the United States joining World War II when John F. Kennedy was actually pro. So when John F. Kennedy was a senator and he ran for his presidential bid, Martin Luther King was actually in jail at the time. And
all right,
John
look,
Kennedy
this is going on. This is going on a tangent. This is going on a tangent. All right. So look,
a tangent. I'm laying out history.
Right, but okay. But one at a time, one point at a time. You're talking about a civil rights decision of the 1880s. Okay. Overall, had been overruled towards the point of the Civil Rights Act nearly 100 years later that found that to be unconstitutional. And I would think that judges of the 1880s were not all that enamored towards the idea of racial equality in America towards African Americans as they were 100 years later. And to say that to say that racist conservative judges set the precedent that one should be allowed to discriminate and that it's unconstitutional to do away with discriminatory practices is antithetical to the fact that we know that it is unconstitutional to discriminate because it denies them the right towards transport,
but the Supreme Court overturned that after Barry Goldwater voted on the Civil Rights Act, right? But prior to,
why are you referencing it?
Because beforehand it was a Supreme Court ruling in 1883. So you would, at that point, you'd be asking somebody who values the Constitution above all else to go against the Constitution in order to vote for this act, and he was not going to do it. However, he was always very pro civil rights.
Does that make it not problematic? Does that make that stance not anti-civil rights?
No, he was very pro civil rights. He just didn't agree with Title II and Title VII. That was
okay. One cannot argue 2 points at the same time.
Ruled on it because the Supreme Court has
already ruled on it. The Supreme Court of the 1880s.
Now,
right.
Okay, it doesn't
of Reconstructionist era. It does. The history of that matters. Okay, because that was a point just after slavery had ended, and they were still deciding whether or not African Americans were afforded equal rights under the law. They decided at that point that they weren't. That's a problem.
Okay, so again, you would be asking him to go against the Constitution to vote for
just because the Constitution decided it was okay to discriminate.
Can I finish? In 1957,
that's a bad point.
In 1957,
no, stop. It's a bad point to say that because the Constitution or the judges decided it was constitutional to discriminate doesn't mean discrimination is okay or lawful or should be deemed
it meant that
under the
people
law.
had the right to determine whether or not they wanted to interact or sell goods, buy goods, whatever the case was.
Okay.
You can't infringe on somebody else's rights. Okay.
If the Supreme Court decided today that no one could own guns, would that be okay?
Hold on a second. So having said that,
no, just answer that, please.
Can I finish
No,
and then I will
this is my
answer your
life,
question?
man. This is my life.
Can I finish my point and then I will answer your question?
You may not. You may not. You will answer my question first and then finish your point. If the Supreme Court ruled that this is my life, if the Supreme Court ruled that no one can own guns and that was then the precedent set, would that make it okay?
They would never do that because they can't touch the original 10.
They could.
No, they can't.
They could. They could deem certain guns. They could deem certain guns unlawful for you to possess. They could ban the distribution of them or manufacturing of certain weapons.
Okay, great. I answered your question. So can I finish my point now?
No, you didn't. You just said they couldn't. They can.
Yeah, I
they could
answered your
absolutely
question. I answered your question. So can I get back to finishing my point?
Overrule that.
Can I get back to finishing? Can I get back to finishing my point now before you pivot?
They deemed slavery was lawful, and then they didn't. Right?
Okay. So again, can I finish? Can I finish?
Okay.
Wait, since I answered your question before you pivot and move the goalpost, please.
That wasn't how did I move the goalpost?
Because you went to the Second Amendment.
Okay, if they did away with the voting rights of women, that's not one of the original 10, and said that we repealed the 19th Amendment. I know. They decide that we can repeal the 19th Amendment, that it's no longer lawful for women to vote.
Because
is that then the precedent that one should abide by? Is it then permissible for the law to discriminate the right of women to vote?
Okay, so the 19th Amendment is not in the original 10. The original 10 are
I know, that's why I brought it up. That's why I brought it up.
So I don't care about anything that's not in the original 10.
The 13th and 14th and 15th aren't either.
Okay.
And what that 1883 ruling ruled was that it was not lawful for them to do away with discriminatory politics.
Okay, so again.
Are you not tracking?
Yeah, no, I'm definitely tracking. But my point is, I don't really care about any other amendment that was made past the 10th Amendment. The reason being.
Reference the 13th and 14th and 15th Amendment.
Can I finish?
You do, though. You do, because 1883, 109 U.S. 3 references the 14th Amendment.
Okay, so I was talking about the Second Amendment. See, this is why I don't like when you move.
Oh my God, track the conversation. Track
no,
it. Okay?
Well, can
track
you not
it. Track it. Please track it. I'm not pivoting. I'm not pivoting because you said that the original 10 don't matter. You said the original 10 don't matter. So we're referencing the original 10 do matter. Okay. You said that they cannot touch those.
They cannot.
So okay, track it. 103 U.S. 3 is referencing the 13th and 14th Amendment. I'm saying if conservatives referenced the 19th Amendment and said that that was no longer constitutional, would it be okay for the Supreme Court to rule that women no longer have the right to vote?
Sure. Because it's not in the Bill of Rights. It's not in the Bill of Rights. The Bill of Rights are the ones that...
Shut up. No. You are a citizen of America. Be you a man or a woman. and you ought to be guaranteed the right to vote, regardless of the basis of sex, race, ability, or what have you. And to argue that that is a constitutional thing to do just because a Supreme Court decides on it doesn't make it any less wrong or problematic.